Hello everybody, in today's video we will be doing the chapter 6 of Business and Technology ACCA, External Analysis, Political and Legal Factors. So before doing this, I request you all to watch the videos of the previous chapters as well. The link is given in the description box below. Make sure you check them out before watching this one. I'm also referring to Kaplan's study text. So there are various factors which affect an organization. In this chapter, we'll be seeing the political and the legal aspect of it. Introduction. In order to fully understand an organization, we need to examine the environment that it operates in. Essentially, we need to learn about the world around it. The analysis should include the following chapters: political or legal factors, economic factor, social or demographic factor, which we've done in chapter 8, technological factors. Reviewing these factors, it is often referred to as Pest analysis. P is political, E is economical, S is social, and T is technological. In addition, we will need to examine the organization's competitors, which we'll be doing in the following chapters. Pest analysis. So, pestle analysis is where legal is separate from political. Step analysis, where pest is reordered. Pestle analysis, where one of the E is economical and one is ecological or environment. Illustration 1. Introduction to pest analysis. For example, a haulage firm might monitor the following. Okay, so what is a haulage firm? Can you think about it? So, haulage firm is a firm that transports goods by lorry. So, what are the factors which influence a firm which transports goods using lorries? Let's see the political factors. Fuel tax, government steps to reduce pollution from lorries, congestion charges in cities, plans to build new roads, road blockades due to strikes, example in France. What are the economic factors? State of the economy. A downturn would result in less trade. Fuel is a major cost, so oil price movements will be seen as significant. Most hauliers borrow to purchase trucks, so a rise in interest rates would increase costs. Social. Predicted car numbers and usage would affect the likelihood of traffic jams and hence journey times. Public concerns over safety would result in lorries being banned from certain routes and reduction in speed limits. I'm just reading this illustration because I think it's very self-explanatory. Technological. Developments in route planning, anti-theft devices, tracking systems to monitor driver hours, developments in tire technology. Competitive rivalry from other hauliers, threat from substitutes, example haulage by rail, threat of new firms entering the market. Political systems and government policy. What is a political system? So, first we'll begin with seeing what exactly is a political system. So, it is a set of institutions and political organizations, interest groups such as lobby groups, and the relationship between them, the rules and norms that govern their functions, such as constitution and the election law. There are three levels of political systems that organizations have to take account of. So, what are the three? The first one is global, which is worldwide, such as the WTO, World Trade Organization, European Union legislation. National is national government policy, local is local departments, and so on. So, what are the three levels of political systems? World, which is global, national, and local. Global, national, and local. Sources of legal authority include. So, there are various sources of the legal authority in the UK which we are seeing. The first one is supranational. So, before coming to supranational, let's see what national is. So, national governments through acts of parliament, senior courts such as senior court in the UK, other major courts through the principles of case law and the setting of precedents. So organizations which come under national are something which is in the UK, inside the UK. What comes inside the UK is national. What is supranational? Supranational as the organizations which is throughout the world. It's not just specified to the UK, but it's also to the world. You get it? So, like UK is national, and the international organizations are supranational. They're superior than the national. For example, the UN, United Nations, International Court of Justice, European Parliament, European Courts, something which is more than the UK. And what is regional? Regional is basically local. Regional or federal government, example Welsh Assembly in the UK, state government in the USA. Local councils through the use of bylaws. How can the government affect an organization? So there are two ways in which the government can affect an organization. The first one is the government policy. So the policies the government make can obviously affect an organization, right? So there are two ways in which the government can affect any organization. The first one is government policy. So political system and government policy. Let's see how the political system and the government policy like affect a business organization. The first one is housing. Obviously, when the government develops new housings, when it has new housing developments, then the people living in that housing area, they will be having some demands of shops and various basic amenities. So new housing developments can give opportunities to house building firms and will create new communities that will demand shops, leisure facilities, etc., giving opportunities for firms in these industries. The second one is crime. Crime policy can affect the firms that specialize in security. Education. Education policy can affect the availability of suitable potential employees for firms. Defense. Defense policy will primarily affect arms manufacturers. Closure of a military base could have serious implications for local suppliers. Healthcare. Healthcare policy has implications on the drugs, on the medicines, and the equipment manufacturers, and also on the private hospitals. Energy. So the policies which are regarding to the choice of the energy sources will be critical to power generators. So the industries in the power area in the energy sector will be affected by the energy laws. Environmental. So targets on greenhouse gas emissions will affect major manufacturers due to increasing global warming. So if some organization does not, it has to comply with the environmental laws. Farming. Government support through subsidies is critical for many farmers. So when government has laws based on like subsidies and various things, then it obviously affects the organizations, right? Town planning. National plans to build new roads could influence business location. So when new roads are built, it affects the location of the business. On a local level, firms need to obtain planning permission for a new factory or to open new shops or build new houses. Domestic. A government may use regional development grants to attract new employees to areas of high unemployment. A government may use regional development grants. So when there are regional development grants, it can attract new employees to areas of high unemployment, right? Foreign. Protectionism. Trade relations with other countries, ban on the sale of arms to Iran, obviously. So foreign policies also affect. Moving on. The first way which the government can affect is the policies. Now we have the other way that the governments can affect the organization. It is by direct legislation, by putting a legislation on certain things. Organizations must comply with appropriate legislation. Failure to do so could result in fines, closure, bad publicity, or loss of customers. Obviously, when a business organization does not comply with the legislation, it faces problems. Most industries have specific legislation that they have to comply with. Example, food labeling in the food industry. However, there are a number of pieces of legislation that apply to most or all organizations. These are some basic legislations which every single must follow. So these include employee protection, data protection, health and safety, and consumer protection. So these are common for all of the organizations. Everyone must follow this, right? So now let's come to test your understanding 1. Consider the following statements. Which is correct? Okay. So, senior courts are a source of supranational authority. Is it correct or no? It is not correct. Why? Because senior courts are inside the UK, they are national. They are not supranational. Okay? So, the next one, legislation and policy can be both used by the government to affect the organizations. This we have just done that there are two ways in which a government can affect the organization. One is by legislation and the second is by policies. The second is by policies. So the answer is this, which is B, which is 2 only. Moving on, employee protection. Within many countries, the national governments have passed legislation which protects employees from unfair treatment by their employers. This type of legislation is often designed specifically to cover termination of the employment of a worker. So we have various employee protection acts in the UK as well as the rest of the countries as well, but we're talking about UK to protect the rights of the employee or to like not have them being terminated by the employer. Dismissal. Organizations usually dismiss workers by terminating their contract. Sometimes employees may resign because their employer has breached the terms of their contract of employment. This is known as constructive dismissal. Okay, so what is dismissal? Dismissing somebody, dismissing your employee. So when I want to fire, it's basically firing people. So you can fire people, right? Which is, and if you do that without giving them time or without a proper reason, then it is unfair. And what is constructive dismissal? Sometimes the worker is forced to leave. So on document, it shows that the worker has left by himself, but that's because the employer has breached the contract. Like for example, reducing the wages without agreement, allowing them to be bullied or harassed in the workplace. So they are not directly firing them, but they are doing things which forces the worker or the employee to leave themselves. That is known as constructive dismissal, which is also unfair. In either case, there is normally a statutory minimum notice period that must be given by either the employee or the employer to terminate the contract. Employees are usually entitled to a written statement of the reasons for their dismissal. Under the Employment Rights Act in the UK, to be fair, an employee must have been dismissed for one of the following reasons. They lack the capability. So these are the reasons in the Employment Rights Act in the UK. Okay, what are the fair reasons for dismissal? The first one is that they lack the capability or qualifications of a job. Fair enough. They were guilty of misconduct, such as dishonesty or theft. Fair enough. The job was redundant. The organization no longer needed them. Fair enough again. They were dismissed for legal reasons. For example, some jobs require employees to have no criminal record. So these are some reasons which it is okay if someone dismisses someone, provided that they have been given enough time, notice period. So lacking the capability of the qualifications. They were guilty of misconduct. The job was redundant, which means that the employees don't need them anymore because of various reasons. They were dismissed for legal reasons, like if they have a criminal case against them. Okay, legal reasons, capabilities, dishonesty or theft, and the job was redundant. These are the reasons. If an organization is unable to prove that a dismissal was fair, they may be accused of unfair dismissal by the employee whose contract has been terminated. So, if an organization is unable to prove that a dismissal was fair, they may be accused of unfair dismissal by the employee whose contract has been terminated. So, if an organizer, in an organization, if the employer dismisses the employee for no reason or no good reason by unfair reasons, then the employee whose contract has been terminated. So the employee can basically accuse the employer of unfair dismissal. Unfair dismissal occurs when an employee has been dismissed for an unfair reason, like one of that is not on the above list of fair reasons. In the UK, unfair reasons could include pregnancy or parental leave, joining a trade union, discrimination over an employee's religion, ethnicity, gender, or sexuality. So, if an employee is dismissed based on these reasons, then it is unfair. Note that unfair dismissal is not the same as wrongful dismissal. Wrongful dismissal occurs when an employer breaks the terms of the employee's contract during the dismissal, for instance, by not giving the proper notice period for dismissal. So, let's see what is unfair dismissal and what is wrongful dismissal. These are two separate things. So, unfair is when if a person is dismissed because of if they are pregnant or if they have a parental leave or based on their religion, caste, gender, and other forms of discrimination, or else if they join some trade unions, joining trade unions. If these are the reasons for an employer to dismiss somebody, it's unfair. What is wrongful? Wrongful is when the contract which was made that was breached, or the contract is not followed by the employee, or if notice period is not given, notice period of the decent time is not given, then it is wrongful. So unfair are these reasons, and wrongful is when the contract is not being followed, or when the notice period is not being followed. It is important that the organization follows its internal disciplinary policies in the run up to any dismissal. Failure to do so can lead to expensive and time consuming legal action being brought by ex employees of the company. Redundancy. So, redundancy is a form of dismissal which occurs when an employer needs to reduce the size of the workforce. So, when they no longer require the workforce, and that's why they want to dismiss, that is known as redundancy. Legislation in this area gives several typical rights to the employee being made redundant, which includes the right to consultation. So, you need to consult them, the employee, before you just dismiss them. The right to a fair notice period, this we have done. The right to redundancy pay, which will vary depending upon the circumstances that you need to pay them. Right of redundancy selection to be carried out fairly. So, selecting the employees who will be dismissed should be on a fair basis. So, what are the four? Right to consulting, you need to consult them. Right to consultation, right to give a fair notice period, and if there is some redundancy pay, that has to be paid, and the redundancy selection should be done on a fair basis. Again, failure to provide these rights may open the organization up to legal claims from any employees who have been made redundant. The principles of data protection. As the business world becomes more complex, organizations are holding increasing amounts of data about individuals. So, this is an important topic. So, it is the principles of data protection. Protecting the data of the employees. As the business world has become more complex, organizations are holding increasing amounts of data about the individuals. Data protection is concerned with protecting individuals against the misuse of this information. So, data protection protects the individuals from the misusing of their data, of their information. Everyone responsible for using personal data has to follow strict rules called data protection principles. The GDPR. Okay. GDPR. What is GDPR? The General Data Protection Regulation. GDPR, General Data Protection Regulation, is an EU is European Union, law introduced in 2018, which aims to make sure that the information is used fairly, lawfully, and transparently, used for specified explicit purposes, used in a way that is adequate, relevant, and limited to only what is necessary or what is required, accurate, and where necessary, kept up to date, kept for no longer than it is necessary. So, if the work is done, you need to remove the data from there. handled in a way that ensures appropriate security, including protection against unlawful and unauthorized processing, access, loss, destruction, or damage. A data user is responsible for the security and protection of the data against unauthorized access, alteration, destruction, disclosure, or accidental loss. Personal data should not be transferred to another country outside the European Economic Area unless that country ensures an adequate level of protection for the rights and freedoms of data subjects in relation to the processing of personal data. The Data Protection Act 2018 supplements the GDPR and incorporated into the UK law. So, what we've just seen is data protection. So, the GDPR, the General Data Protection Regulation, is an EU law introduced in 2018 which aims to make sure that these are the reasons which we've read. The Data Protection Act, GDPR, the General Data Protection Regulation. There is a strong legal protection for sensitive information such as, so these are the sensitive information where there should be a strong legal protection: race, ethnic background, religious beliefs, political opinions, trade union memberships, genetics, biometrics, health, sex life, or orientation. Race, political opinions, trade union members, genetics, etc., and sex life or orientation. So these are sensitive information which need to be protected at any cost. The need for consent underpins the principles. Individuals must opt in whenever data is collected, and there must be clear privacy notices. Those notices must be concise and transparent, and consent must be able to be withdrawn at any time. Huge fines higher than Euro 20 million or 4% of global turnover are enforceable for non-compliance. The right of data subjects. Under the Data Protection Act 2018, you have the right to find out what information the government and other organizations store about you. So you have the right, if you want to find out what information the government and the other organizations store about you. These include the right to be informed about how your data is being used, access personal data, have incorrect data updated, have data erased, stop or restrict the processing of your data portability, allowing you to get and reuse your data for different services, object to how your data is processed in certain circumstances. So, according to the Data Protection Act 2018, you have the right to find out the following uses, which are right to be informed how your data is being used. You can access your personal data. You can have, you can see if incorrect data is updated. You can update the incorrect data. Have data erased, stop or restrict the processing of your data, data portability. If you require the data for some other purpose, you should be able to take. Object to how your data is processed in certain circumstances. So that was about data protection. Now we come to data security. Data security is concerned with keeping the data safe from various hazards that could destroy or compromise it. These include physical risks and human risks. So, till now, we were seeing the data protection. In data security, only two things are there: either human risk or physical risk. So, what are physical risks? Impact on the physical environment in which the system exists. Example, fire or flood. So, impact of the physical environment. So, that comes under data security. Human risks. Access is gained to the system by an unauthorized user, either physically or remotely, by hacking, virus infection, fraud, etc. Illustration. In April 2011, hackers gained access to over 77 million PlayStation user accounts held by Sony. These accounts included personal information and credit card details. So many people lost their money by this. So what is this coming under? This is coming under the human risk of what? Data protection or data security? Data security. So this security failure leads to significant loss of reputation and sales to Sony. So people will obviously not buy from them, right? Because they got let down by them. Moving on, test your understanding 2. Jacob has found that a utility supplier has sold information about him to a market research company. Is this an issue of data protection or data security? So it is about selling the information. We have, is it a human risk or a physical risk? No. So this comes under data protection. There is no indication of the market research firms that it has not been mentioned that they used hacking, right? So this comes under data protection. The main risks to computer systems and the data they contain include the following: potential threats. The main risk to the computer systems and the data they contain include: what are the potential threats? Physical damage due to fire, flooding, terrorist acts, power failure, other environmental, heat, cold, humidity, dust. Countermeasures. What are the measures which an organization can take for this? Well documented fire procedures, staff training, provide fire extinguishers and smoke heat detectors, fire doors. Computer equipment might be located in a segregated area in which there is air conditioning and dust controls are operated effectively. There are backup generators, off-site facilities where we can have some backup to cater for the possibility of total destruction in the in-house computer equipment. Off-site backup copies of data files. The human damage caused by human interference, such as unauthorized access, so restricted access, we can have computer room, we can have some pins or restriction, a password, closed circuit TV, and security guards. Hardware can be physically or electronically tagged to sound an alarm if it is removed from the building. Hardware can be locked down. Operational problems such as program bugs and user operational errors, thorough testing of new programs, strict operating procedures, adequate training of all staff members, data corruption, viruses and hackers, antivirus, firewall software, passwords, offsite backup copies of data files, data theft, example fraud, data encryption techniques, passwords and user numbers, physical access controls. Ragu Limited holds data about many of its customers. It has recently set up an off-site backup of this data to improve its data security. Which potential data security threat will this measure most likely reduce? It will reduce D. So the answer is D. Off-site backups will protect us from the fire, flood, etc., not from theft, not from hacking, not from viruses. Health and safety in workplace. There are a number of potential hazards in any workplace. Some examples include unsafe electrics, torn carpets, poor lighting, wet floors, top heavy filing cabinets. To deal with this, many countries have created detailed legislation covering health and safety in the workplace. The law typically puts the responsibility for the health and safety on both the employer and the employee. So, what are the responsibilities of the employer? The employer has a duty, amongst other things, to provide a safe working environment to prevent risks to health, ensure that plant and machinery is safe to use, and safe working practices are set up and followed, inform staff of any potential hazards, provide adequate first aid facilities, check that the right equipment is used and that is regularly maintained, set up emergency plans. What are the employees' responsibilities? They have to take reasonable care of their own health and safety. They have to take reasonable care not to put other people at risk. They have to cooperate with their employer to ensure that they have adequate training and are familiar with the employer's health and safety policies. They have to report any injuries suffered as a result of performing their job, inform their employer if anything affects their ability to work safely. Breaches of health and safety. If employers fail to provide a safe and healthy working environment, they may be in breach of common law, enabling employees to make a civil claim against them. So if employers are not following their duties, then the employee can put a claim on them. In addition, they may be guilty of a criminal offense and be open to prosecution. Health and safety is concerned with eliminating risks. Is it true or is it false? It is false. Why? Because the media can sometimes give this impression that health and safety is about taking practical actions and controlling real risk. It is not possible to eliminate all of the risk. There are always risks. It's impossible to eliminate 100%. So the statement is false. While Elizabeth was running down a staircase at work, she tripped and injured herself. Who is responsible for this action? The act, the person who is responsible is Elizabeth herself, because why was she running down a staircase in the first place? Employer can't stop that. It was her choice. So it's Elizabeth's fault. Consumer protection. Many countries have legislation which attempts to protect consumers from falling victim to unscrupulous or unethical businesses. These laws are often very complex and will vary from country to country. However, for the purposes of your exam, only a basic understanding of the common principles found in such legislations are required. So, first we have consumer rights. Many countries have legislation designed to protect consumers when they purchase goods from other individuals or from businesses. In the UK, this is dealt with by the Consumer Rights Act 2015. Consumer Rights Act 2015. This has many features, but there are several key principles built into the act. They include, so we're doing Consumer Rights Act 2015. The seller must have a legal title or ownership of the item they are selling. So the seller must be having the legal title or identity. The goods sold must be satisfactory quality and fit for their intended purpose. When a buyer makes a purchase based on the description of an item, the goods must correspond with the description. When digital content, example online films, games, ebooks, is faulty, consumers are given a clear right of repair or replacement. So first one is that in the Consumer Rights Act 2015, the first one is that the employer must have the legal identity or legal title or ownership of the things they are selling. The goods sold must be of good quality. And when the buyer makes a purchase based on description, it should match the description and the digital content. If something is wrong in that, they must get a refund. In addition, this legislation also extends to the provision of services, not just goods. So it is also applicable for services. So, what are the expectations from services? They should be carried out with reasonable skill and care. They should be completed within a reasonable length of time. They should be completed at a reasonable price. So, time taken, skill and care, and price. These are the three factors. Illustration. Service provision. The provision of an accountancy services would fall under the consumer rights legislation. Should the accounts contain errors or be prepared too late for filing deadlines due to the firm of accountants preparing them, the customer may well have recourse against the firm. Test your understanding. 6. Elena buys a television from After PLC, an online retailer of homewares. When the television arrives, she discovers that it is a different model and size to be the one she ordered. She also finds that the screen image is blurred and remote control is faulty and does not work. Why is After PLC likely to have breached local consumer rights? So, first thing, there are two probable reasons. Firstly, she bought the television based on the description given. As the description has not been matched, that is one reason. Secondly, if it is faulty and damaged, you're eligible for a refund, right? Because the quality is not okay. So, Alina should be able to return the item for replacement or full refund. Okay, simple contracts. Generally, a contract is a legally enforceable agreement. What is a legally enforceable agreement? It is a contract between two or more parties. Such a contract is known as simple if it is not required to be in any particular form. So it can be verbal or it can be written as well. It is a commonly held misconception that all contracts must be written in order to be legally binding. In fact, many contracts can be in other forms such as verbal contracts. However, in the event of disputes between the parties, non-written contracts, they can be hard to prove, but it doesn't mean that that didn't exist, right? Features of a simple contract. Simple contracts must have the following features to be valid. So, what are the following features in order for contracts to be valid? The first one is agreement. The parties have agreed on the terms of contract. Normally, this means that one party has made an offer that has been accepted by the other. So, the first thing is agreement, that both the parties have to agree to the terms which they are, signing the contract for. The second one is consideration. In many countries, both parties usually get some value from contract. Each party must offer some consideration to the other. So when you have a contract, you guys agree that I will give you this product, you will give me that product, or I will give you this service, you give me that. So there is some kind of consideration. We provide consideration for each other, right? Intention to create legal relations. Both parties must clearly intend their relationship to be legally binding. For example, an informal arrangement to go shopping with a friend would not normally constitute a legally binding contract. So, there should be an intention to create a legally binding relation where it's like legally also binded. Capacity and legality. Each party to the contract must have the capability to enter the contract. So, capacity and legality. So, the reason for which the contract has been made, the organization must be capable to do so, right? Each party to the contract must have the capability to enter the contract. In many countries, individuals under the age of 16 cannot enter a legally binding contract. In addition, contracts cannot be formed for the purposes of an illegal act, like contract to commit murder. It is not legally enforceable. So, the contract which they're making, it should be legal, and it should be there should be capacity, which means they must be capable to fulfill the contracts. So, what are the things which we've seen for a contract? First of all, it should be an agreement. Secondly, there should be consideration. And then it should be intention to create legal relations and capacity and legality. Agreement, consideration, intention to create legal relations, capacity and legality. By creating legislation surrounding simple contracts, the government can protect consumers from being taken advantage by businesses or other individuals. For example, children will be unable to sign binding contracts as they are unlikely to be fully aware of the consequences. Moving on to test your understanding 7. John has agreed with Matteo that he will pay him $200 if Matteo maintains his garden for the next year. At the end of the year, John refuses to pay Matteo. In spite of Matteo having undertaken the work agreed, John has told Matteo that because the contract was not written and signed by both parties, he has no obligation to pay. Is John correct? No, John is not correct. Why? Because we saw that even though it is difficult to prove a verbal contract, a contract is a contract, be it verbal or be it written. Now we come to the practice questions. Government may create dash. If an organization fails to comply with this, it will lead to prosecution, fines, and even closure. So government may create direct legislation. So it can create legislation, and if you don't follow it, there are fines. Which of the following is not a typical fair reason for dismissal? Lack of qualifications, gross misconduct, high salary, redundancy. Obviously, it is high salary. Which of the following is one of the rights of individuals under typical data protection legislation? Immediate access to personal data at any time, the right to erase personal information through an application to the data holder. No decision should be taken against an individual on a purely automated basis. The right to prevent data being processed for profit of others. So, which one is one of the right? The answer is C. While individuals have the right to access their personal data, this may involve a written request being made and the payment of a fee. This is unlikely to happen instantly. Application for the erasure of data may have to be through the courts. Data processing can only be prevented if it will cause damage or distress to the individual or if it is purposes of direct marketing. So it can't be done on an automated basis. Dash is concerned with keeping data safe from various hazards that could destroy or compromise it. The answer is B, data security. Consider the following statements. Employees have the sole responsibility for the health and safety of their employers. Employees have the sole responsibility. Is that true? Not the sole responsibility. That's not true. As long as employers have adequately trained their staff about potential hazards they will face in the workflows, they have discharged the health and safety responsibility. Even that is also false because there can still be some things which they're not following. So the answer is D, neither. Sarah is a manager at V company. As part of her contract with V, she is not supposed to hire any employees who are female or over the age of 35. This contract is subsequently found to be unenforceable. Which of the features of the simple contract is missing? So, what it is missing is B, which is legality. Why? Because the contract involves discrimination against some potential employees, which is illegal in most jurisdictions. So, it is B, legality. Also, remember that a contract is not valid if it requires one or more parties to break the law. 14. Which of the following is a requirement of typical consumer protection legislation? Consumer protection legislation. All goods and services must be reasonably priced. Yes. Goods should be of good quality. Yes. The seller must have legal title to the goods being sold. Yes. Buyers do not have to make payment until after the receipt of goods. Yes. So, what is the answer of 4? While services should be completed at a reasonable price, goods and services do not. In themselves, they have to be reasonably priced. Goods have to be fit for the purpose rather than the good quality. There is no requirement for buyers to pay in advance. Okay, so the answer is to the following is typical of there is the wrong answer in the book behind, but buyers do not have to make payment until receipt of the goods. That's also good. The seller must have legal title, so the answer is C. Test your understanding. 15. Sources of legal authority may be supranational, national, or regional. Within the UK, for example, these sources include national government. Okay, these are the things which A to H which controls supranational. So we need to do supranational. National government through acts of parliament. This is not supra. United Nations is supranational. Local council is regional. UK Supreme Court is of UK, European Parliament is supranational, International Court of Judgments is supranational, European Court of Justice is supranational, UK Crown Court judgment is not. So the answer of A is B, E, N, F, G. B, E, F, G. We're right. Moving on. Redundancy is a form of dismissal which occurs when an employer needs to reduce the size of their workforce. Consider the following employee rights. So these are the rights. Select the 4 A to H which are typically included in redundancy legislation. Okay. So we have to select 4 of the above rights which are typically included in redundancy legislation. The right to refuse redundancy, that is not included. The right to consultation regarding redundancy, that is included. Right to be redeployed elsewhere within the organization, that's also not included. The right to be offered redundancy pay, that is there. The right to be to a fair notice period, yes. The right to fair redundancy selection process, yes. Right to retraining to aid, no. Right to time off work to search for a new job, no. So that's the answer. I hope you understood this chapter clearly. In the following videos, we will be doing the exam kit or the test kit as well. So stay tuned and check the playlist in the description box below. If you have any questions or any doubts or any suggestions, please drop them down in the comment section. Thank you.